So, yes, many thanks to Serre for inviting me to give you this keynote speech after lunch. Always the right spot. As a multi-stakeholder think tank, it was Serre which was at the forefront of discussions around the design of the regulatory framework for large digital platforms. In my former role as a member of the Council of the BIPT, the Belgian telecoms regulator, I witnessed how many of the authors involved in the current studies were already then pioneering ideas around possible ex-ante regulation at times when competition cases were piling up against large tech players. New regulatory questions were analyzed, and some of the ideas that were suggested in the Serre studies ultimately also found their way into the current regulatory framework, whether it is the DSA or the DMA. This is why I'm honored to be invited specifically by Serre today to speak on the DMA. I will focus my speech on the DMA only, as the Belgian Competition Authority is responsible for the DMA in Belgium. The DSA is handled by my former colleagues at the BIPT in cooperation, notably with media and privacy regulators. So let me start by addressing immediately one of the elephants in the room, the geopolitical context. What should we do with it? And what impact does it have on the implementation of the DMA? Of course, this is first and foremost a matter for the European Commission to handle, not for a national competition authority. I was asked to comment on Serre's policy recommendations, however, and the geopolitical context becomes relevant when we look at the institutional framework of the DMA implementation. With regards to this framework, the authors refer to, and I quote, the risk that decisions are perceived to be taken on political rather than on administrative grounds, which we think should be avoided, end of quote. The authors refer to the complexity of dual reporting lines within the Commission and different approaches between the teams, one being the antitrust approach and the other a regulatory dialogue. However, because of the current context, this point becomes obviously also very relevant for other reasons also. Let me therefore state the obvious, something that seems to be useful and necessary these days. Europe should stick to its principles. As one of the biggest markets for the big tech services, Europe should not move away from a regulatory approach that is evidence-based, which has been democratically adopted, and which is now being implemented and enforced with due respect for the rule of law and the substantive and procedural rights of the different stakeholders involved, including the rights of gatekeepers. So why are we even discussing this today? Well, it is clear, in its broader role, the Commission is confronted with the current diplomatic agenda vis-à-vis our major trading partners, some of which happen to be the country of origin of the major tech companies. At the same time, the Commission is of course also the exclusive enforcer of the DMA. In this capacity, it has a more technical role, which is very close to that of an independent regulator. In fact, as a result of the DMA, the Commission in a way became a sector regulator. This double role may raise tensions. Yet, with the authors of the paper, I also believe that the enforcement of the DMA should not be distracted by the political dimension of the Commission's role. This is one of the reasons why, in line with the policy recommendations of the Serre report, I would also favor the idea of ultimately creating a European digital authority. This is not urgent, however. as long as the Commission sticks to the rule-based decision-making that characterizes the DMA. And that is exactly what the Commission is doing in the current context. This can be exemplified by the fact that the Commission is ramping up pressure on gatekeepers to comply with the DMA. In one case, the Commission sent 2 sets of preliminary findings for non-compliance with the DMA. In another case, she adopted 2 so-called specification decisions on measures which a gatekeeper has to take to comply with certain aspects of the DMA. So I do not think that politics are taking over from legitimate expectations created by the DMA. Okay, now that that elephant is out of the way, let me go back to my core business. I was asked to talk to you about the role of national competition authorities. As the report of SER says, it refers to a limited role for NCAs as far as the DMA is concerned. So I guess the organizers also had a very limited speech in mind. No, seriously, they are right. NCAs have a limited role compared to the European Commission with regards to the DMA. However, the fact that NCAs have a limited role does not mean that that role is without any importance. The report correctly identifies a primary role for NCAs in advocacy on the DMA towards national stakeholders. In this regard, it refers to initiatives such as the one taken by my authority in cooperation with my colleagues of ACM to organize forums for business users and publishing easy-to-read guides on how the DMA works. That's normally where I have to show you that guide that I don't have with me right now. But there is a guide on DMA, you can find it on our website. Beyond that, however, NCAs are probably the more obvious place to go for local companies, SMEs or national federations, to address their complaints as regards the application of the DMA. NCAs will then help examining these complaints in the light of the DMA rules and contact the European Commission if it considers that there is indeed a potential issue. Smaller, local players are often not as familiar with the European Commission and will not spontaneously contact the Commission for a problem with a gatekeeper. NCAs therefore have an important role to play as a kind of first-line authority for these complainants. As far as my authority is concerned, more advocacy work is still needed to raise more awareness with local players. Indeed, so far, the Belgian Competition Authority received only one real complaint, which was analyzed under the DMA rules and transferred to the Commission, who now has the lead on that case. Also, I want to mention that when promoting the DMA, we must be realistic and manage expectations in view of the following circumstances. First, the DMA and its enforcement is still very young, and nearly every question is new, also from a technical perspective. As mentioned in the SER papers, it is an iterative process rather than a single-shot game. An iterative process obviously takes more time. Second, the team and the enforcement capacity at the Commission is limited, considering the work ahead. And I want to pay a tribute to pioneers working on the DMA enforcement at the Commission these days. Third, the case pipeline is already quite filled. And yes, as mentioned in your paper, the prioritization of cases may not be all that clear for the outside world. Finally, current and upcoming cases are typically big cases, and sometimes also cases on issues that were already pending with the European Commission prior to the adoption of the DMA, which the Commission is handling now first. In most of these first cases, the main issue at stake is more often the contestability of the market, or the contestability objective of the DMA, one of the 2 key objectives of the DMA, next to the strengthening of the internal market, of course. There is, however, also another objective that also lies at the heart of the DMA: fairness. And this second objective of the DMA will typically be at issue in gatekeeper relationships with smaller players, such as the ones that we will be talking to as national authorities. Indeed, the protection against a fundamentally asymmetric commercial relationship with gatekeepers is often what small companies and business users in DMA terms will be confronted with. For example, standard terms and conditions that are being presented as take it or leave it, gatekeepers on which small firms depend for their business and that are unilaterally changing service conditions, lock-in situations, imposing price parity clauses, etc. Yet, for the time being, the fairness objective seems to be less prominent in the present pending cases. Be careful, this is not a criticism. We are at the very beginning of the enforcement of the DMA, and you need to build up a decisional practice through these first cases. We must realize, however, that when we are advocating the usage of the DMA by smaller companies, we also raise expectations when companies actually follow up on such advocacy by filing a complaint. And given that the DMA enforcement is centralized at the level of the European Commission, smaller cases, or cases where the impacts are limited to one single member state, for example, risk being neglected. Even if there are legitimate reasons for doing so, in terms of opportunity and priority management, which as such have nothing to do with the merits of the case. As the Serre paper mentions, business users and third parties that have engaged in DMA activity could nevertheless be discouraged and disillusioned if there is no resulting impact from such engagement. In any event, going back to the role of NCAs, to be frank, I'm not sure that the division of tasks as suggested by the Serre recommendation between, on the one hand, advocacy at NCA level and, on the other hand, enforcement at the Commission level would lead to a more satisfactory outcome. On the contrary, NCAs would be promoting an instrument on which they have no real control. Yet, despite the fact that it is centralized at the level of the Commission, NCAs can also usefully contribute to the enforcement of the DMA. Indeed, NCA staff members can join the joint investigative teams at the Commission and make sure that more DMA cases are being handled, including fairness cases. So for those who don't know what the joint investigative teams are, these are teams in which officials of the NCAs are working or being seconded to the Commission to be part of the joint DG Com, DG Connect DMA team. The secondment of NCA staff increases the enforcement resources of the Commission, generally, of course, to the benefit of the successful enforcement of the DMA. At the same time, the NCA staff also gains valuable experience and expertise on the DMA, so it's really a win-win. As far as the Belgian Competition Authority is concerned, we sent one staff member from our digital team as from September 24, and I'm optimistic that this will further enhance the links between the work of our authority on the one hand and the work of the Commission on the other hand as regards the application of the DMA. There may be yet another way for NCAs to assist in the enforcement of so-called smaller cases, which may not catch the priority at the Commission level. Indeed, the DMA rules, or at least some of its provisions, such as obligations of Article 5 to 7, are directly applicable and can therefore be invoked in national courts. In this very early stage of the regulation, judges may, of course, not be familiar with these rules, however. Courts are therefore not the natural place to bring a DMA-related dispute. This, however, is where the NCAs could also play a useful role by intervening via amicus curiae in litigation around the DMA. The Belgian Competition Authority regularly intervenes with amicus curiae on competition matters, most often upon the request of a judge, but it can do so also on its own behalf. Having said this, Besides being a first-line collector of complaints, as mentioned earlier, NCAs, of course, also remain competent for the application of general competition law, application and enforcement of competition law. This remains true also for gatekeepers, which remain subject also to competition law, of course. My Dutch, Italian, Spanish, German colleagues, and the cases they are handling at national level are there to demonstrate that competition law and DMA are indeed complementary, as also confirmed recently by the German Bundesgerichtshof in the Apple AT&T case. The DMA preamble, recital 12, also refers to the fact that it complements competition law. It does not replace competition law. So in this capacity, NCAs can and should continue to apply competition law on gatekeepers, subject, of course, to informing and cooperating with the European Commission in line with the principle of faithful cooperation. This remains an important role for NCAs, especially considering what I said earlier on the potential bottleneck of cases at the level of the Commission in a startup phase of the DMA implementation. Next to the application of competition law vis-à-vis gatekeepers, there is another aspect in which national competition authorities have a unique position in relation to digital players. Indeed, NCAs have also an important role in applying competition law vis-à-vis national platforms, which are not gatekeepers under the DMA and therefore not bound by the DMA rulebook. Yet, national digital platforms can show very similar characteristics to the DMA gatekeepers as far as market power is concerned, or even as regards their behavior towards business users. The Belgian Competition Authority has been confronted with cases around local platforms which are very similar to the DMA cases. Already in 2016, there was the IMOWeb case. IMOWeb, which probably many of you know if you live in Brussels, used price parity clauses to ensure that software developers of real estate agencies would offer to IMOWeb terms at least as favorable as those given to competitors. In view of IMOWeb's position on the market, the Belgian Competition Authority considered such clause to be illegal, and ultimately IMOWeb agreed to remove these clauses from their contracts. Other national digital platform cases have been brought to our attention more recently, similar to the cases which are being investigated in our neighboring countries. In such cases, there can be cross-fertilization between concepts and principles of the DMA, which could be relevant also for competition cases. Just as telecommunications regulation was based on competition cases in the end of the 90s, the DMA regulation is also built on the shoulders of competition cases against big tech companies. Bearing this in mind, obligations of the DMA could serve as an example, or they could be used as a basis for designing appropriate remedies to local platforms which have been found to violate competition rules. Besides infringement cases, I think NCAs could also have a role to play with regards to acquisitions in the digital context. The DMA is not a merger control instrument for the transactions of gatekeepers, even if there is an information obligation as regards acquisitions. There is, of course, the European Merger Control Regulation, as well as national merger control procedures. But as we all know by now, there may be specific circumstances where the turnover threshold is not indicative of the sensitiveness of the acquisition, considering its impact on competition. In such cases, national competition authorities can exercise their competence under their call-in powers, if they exist, of course, or else by using jurisprudence such as towercasts, as the Belgian Competition Authority has done 2 times by now, under Article 101 and 102, but in different sectors. I will not go further into details on the whole Article 22 saga. I'm mindful of your digesting the lunch, which is now again pending before the court in the NVIDIA case. But let me just underline that NCAs, together with the Commission, also have a role in monitoring acquisitions in a sector that is being characterized by extremely high market shares and dominant or even super dominant positions. Let me therefore conclude with this. Based on the reading of the DMA, NCAs have indeed a limited role in enforcing it. However, they have a very important role in making sure that all relevant beneficiaries, small, medium or big, national, pan-national or European players, have access to the benefits of this regulation in order to make sure that all objectives of the instruments are met. Contestability is one of them, and probably an essential one, if we want the market to potentially disentrench vested dominant positions. But fairness is another one of its objectives, and most likely one with a larger group of potential beneficiaries that we will be running into as national competition authorities when promoting the DMA. So let's make sure we all make this a success to the benefit of a vibrant digital market in Europe. I thank you.